Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Can a game warden search your house without a warrant? The short answer is almost always no, but the full story is more complicated and understanding it is crucial for every property owner, hunter, and fisherman. This issue centers on the Fourth Amendment to the U.S. Constitution, which protects you from unreasonable searches and seizures. The Supreme Court has repeatedly said that your home receives the highest level of this protection. This means that for a game warden, just like any other law enforcement officer, to legally enter and search your house, they generally need a search warrant issued by a judge. However, this is where the confusion starts, because game wardens have special powers that other officers don't, primarily because of something called the open fields doctrine. This doctrine allows wardens to enter private land, like your woods, pastures, and ponds, without a warrant because these areas are not considered to have a reasonable expectation of privacy. This is why a warden can be on your property far from your house. But this power stops at your front door, and it also stops at what's called the curtilage of your home. Curtilage is the area immediately surrounding your house that is connected to daily life. Think of your fenced-in backyard, your porch, a detached garage close to the house, or a shed where you keep your lawn equipment. These areas are legally considered part of your home and are protected by the Fourth Amendment. So, while a warden can walk through your back 40 acres, they cannot start searching your shed or peeking through your windows without a warrant. Of course, there are a few standard exceptions to the warrant rule that apply to all police. If you give them consent and say, "Sure, come on in," you have waived your rights for that search. You are never required to give consent. You can politely say, "Officer, I do not consent to a search of my home." Another exception is the plain view doctrine. If a warden is legally standing on your porch and sees an illegal deer tag on a buck through your open garage door, that evidence may be admissible. A third exception is exigent circumstances, which means an emergency situation where they believe evidence is about to be destroyed. To summarize, your house and its immediate surrounding area, the curtilage, are protected. A warden needs a warrant. Your open fields, forests, and waters are generally not protected in the same way, and a warden can enter them. Always remember that laws can vary slightly from state to state, but they cannot violate your constitutional rights. Knowing the difference between your home and your open fields is the key to understanding your rights. Thank you for watching. If this video was helpful, please hit the like button and subscribe to the channel for more content that helps you understand your rights in the great outdoors.